All right, let's just dive right into this explainer. Today, we're figuring out exactly where South African law comes from, because trust me, it is definitely not just found in one dusty old book. The legal system is this living, breathing framework, and understanding its roots is absolutely essential if you want to grasp how justice actually functions today.
We've got a lot of ground to cover. We'll be mapping out this dynamic landscape together, looking at where the law is, the supreme blueprint, legislation and precedent, common and customary law, and finally, secondary and global sources. Let's get into it.
Starting off with Section 1, where is the law? Right off the bat, let's bust a super common myth about how the legal system actually operates.
You know, a lot of people just assume all of South African law is neatly written down by Parliament in one massive, single code. But is that actually true? Is there really just one master rulebook you can grab off a shelf to find literally every single law?
Well, the reality is no. South Africa actually has a mixed multi-source system. It's split right down the middle between codified rules and uncodified traditions. On one hand, yes, we definitely have codified law. These are the rules officially written down in statutes and acts. But on the other hand, we have this massive amount of uncodified law. This isn't written down anywhere officially. We're talking about long-standing customary laws and traditions that, believe it or not, still carry very real legal weight today. So, if you're an attorney, the absolutely crucial point here is knowing which tools are strictly binding on a judge and which ones are just persuasive. Primary sources, those are binding. That means courts absolutely must apply them. We're looking at the Constitution, formal legislation, and previous court precedents. Secondary sources, however, are non-binding. These are things like textbooks written by modern authors or even foreign laws from other countries. A judge doesn't have to follow them, but lawyers use them all the time for their persuasive value to build a killer argument. For anyone navigating the legal system, knowing this difference is really half the battle.
All right, that brings us to Section 2, the Supreme Blueprint. Let's look at the ultimate supreme law of the land.
And when we say supreme, we mean the 1996 Constitution. Absolutely no other law can conflict with it. But you know, it didn't just appear out of nowhere. It was born from a really powerful historical timeline of multi-party negotiations that kicked off after Nelson Mandela was released in 1990. Those intense back-and-forth negotiations gave us the interim constitution in 1993, which then paved the way for the historic 1994 democratic elections. And then finally, the comprehensive constitution was officially approved by the Constitutional Court in 1996.
I want you to think about the Constitution through this absolutely beautiful metaphor. In the context of South Africa's history, the Constitution is meant to have an effect equivalent to a caterpillar changing into a butterfly. It was a profound, radical change that literally breathed new life into the entire legal landscape. The whole design was to completely replace the severe violations of the pre-apartheid era and instead infuse the entire system with human dignity, equality, and freedom.
And this brings us to a really massive concept, transformative constitutionalism. What does that actually mean? Well, it means the state must actively deliver services. We're talking running water, food, healthcare. It's about fundamentally transforming society from poverty to flourishing. It isn't just about protecting your political rights on a piece of paper. It's an active mandate to provide those second-generation socio-economic rights so that citizens can actually thrive.
Moving right along to Section 3, legislation and precedent. Let's unpack how everyday laws are actually made and interpreted by the courts.
So, when society has changing needs, or maybe there are gaps in the law, which are called lacunae, by the way, Parliament steps in to create new legislation, and they do this through 4 very specific steps. First, it kicks off with a green paper to gather public comment. Then comes a white paper, which outlines the actual policy. After that, experts draft a bill, and that gets thoroughly debated in Parliament. Finally, if it survives all that and passes, the president signs it into an official act.
But what happens when the legislation is silent or vague on an issue? That's when attorneys look to judicial precedent, which is anchored by this essential Latin principle, stare decisis. It literally translates to stand by previous decisions. This creates a strict hierarchy. Basically, lower courts are strictly bound by the judgments of higher courts whenever they're dealing with cases that have similar facts. They can't just go rogue.
Now, when attorneys are scouring those previous cases, they are hunting for the ratio decidiendi. That's the true reason for the decision. It's the exact specific legal logic the judge used to resolve the dispute. And it's that specific reasoning, that exact rule, that actually creates the binding precedent for future courts.
Contrast that with obiter dicta, which translates to remarks in passing. You see, sometimes a judge will just offer a hypothetical scenario or maybe an extra thought alongside their ruling. These casual remarks, they do not create precedent. But a really clever lawyer can absolutely grab onto them later to help persuade a court.
All right, Section 4, Common and Customary Law. Let's dive into the unwritten roots of South African law and see how the Constitution forces them to evolve.
Our common law is deeply, deeply historical. It's based largely on old 17th and 18th century Roman, Dutch, and English law. But here's the thing, it can't remain frozen in time. Take the Carmichael case, for example. When the police wrongfully released a dangerous man who then attacked the applicant, the Constitutional Court stepped right in to expand the common law duty to protect women. They essentially ruled that courts have a strict constitutional obligation to develop the common law so that it actually promotes the Bill of Rights.
And then there's custom. Unwritten community habits, like say Cape Point fishermen catching a shoal of fish way back in 1921, can actually become binding law. But they have to meet 4 strict tests. In the famous Van Brader case, the court determined that for a custom to carry the weight of law, it has to have existed for a long time, it must be generally recognized by the community, it has to be entirely reasonable, and the contents must be clear and certain. Hit all 4 of those, and you've got law.
Now, when we look at African customary law, we really have to draw a line between the rigid textbook version and the living, breathing law practiced by actual communities. Historically, official customary law was written down by outsiders, which made it super inflexible and, frankly, often biased. But living customary law, that is unwritten. It's the actual day-to-day practices of the community that organically evolve over time as society itself changes.
A perfect example of this is the Bihe case. It is transformative constitutionalism in action. There was an old customary rule of male primogeniture dictating that only a male could inherit an estate, which meant 2 young daughters were going to be left with absolutely nothing. They'd lose their home. The Constitutional Court invalidated that rigid rule. They developed the living customary law, allowing the eldest daughter to inherit and aligned the custom perfectly with constitutional gender equality. It was a total game changer. And finally, we arrive at Section 5, Secondary and Global Sources. Let's zoom out a bit and examine the non-binding tools and global agreements that help judges interpret our primary laws.
So even though these secondary sources aren't technically binding, any smart attorney is going to use them to persuade a judge, especially when interpreting really complex constitutional rights. We're talking about works by modern authors like academic books and journals, or foreign law like the Canadian Code, or even soft international law, which are global guidelines South Africa hasn't officially adopted yet. They aren't strict rules here, but they are incredibly useful for comparison and for shaping strong, modern legal arguments.
However, you've got to keep in mind that if South Africa officially signs a global treaty, that international law crosses the line and becomes powerfully binding. For instance, when South Africa formally signed and domesticated the Rome Statute, it officially became part of the legal system. On top of that, the Constitution actually demands that courts absolutely must consider international law whenever they are interpreting the Bill of Rights. It's not optional.
So having mapped out this incredible ecosystem of sources, it leaves us with one final, really vital question about the future of justice. From ancient Roman Dutch writings to modern international treaties, we've seen that the law is absolutely not static. If the law is a living landscape, constantly transforming from a caterpillar into a butterfly, how will your generation continue to shape it? Thank you so much for joining me on this explainer. Keep questioning, keep learning, and I'll catch you next time.